Hello, my name is Harold Scott Roth, and I'll be your moderator today. Here at the Hudson Institute and the Center for the Economics of the Internet, we are delighted to have with us today Commissioner Noah Phillips of the Federal Trade Commission. Commissioner Phillips is an outstanding commissioner, expert in all the fields of antitrust and consumer protection in all the areas in which the Federal Trade Commission protects the American public. He has prepared some remarks for us today, and we're very much looking forward to hearing his remarks. Commissioner Phillips.
Thank you, Harold, for that very kind introduction. And thanks to Hudson for inviting me to speak. Hudson has such a proud legacy of influential thought leadership on technology policy and also other issues. Earlier this week, the House passed the Foreign Merger Subsidy Disclosure Act, the idea for which you and I first discussed here at Hudson in December of 2020. So it's an honor to be back. I do have to start with my standard disclaimer that the views I express today are my own and do not represent those of the FTC or any other commissioner. As I near the end of my tenure at the FTC, I've been thinking a little bit more systematically about the policy conversation that has surrounded the agency over the last 4.5 years. Consistent with a political zeitgeist deeply suspicious of a handful of enormous technology companies, politicians, regulators, commentators, and academics are in lockstep that the United States needs to rein in big tech. The FTC has a dual antitrust and consumer protection mission, including data privacy. So the agency naturally finds itself in the middle of that conversation. Today, I want to talk with you about what I fear this conversation all too often lacks, and why that deficit is a prescription for failing to address the real issues that many associate with large technology companies. How should we regulate technology or anything else? I want to start by laying out some elementary steps that I believe must be followed to adopt sensible regulations for pretty much anything. First, define a problem. Second, propose a solution calibrated to address that problem. Third, recognize that all policy involves trade-offs and grapple honestly with the trade-offs, intended or otherwise, that flow from our proposed solution. All of this may sound obvious, but I do think it needs to be said, because too much of the policy conversation surrounding technology lacks even that much. On a podcast earlier this year, Yuval Levin described the difference between the right and the left on economics as the right believing that the short term is a function of long-term conditions, and the left believing that the long term is the function of short-term policy. Progressives will spot what they believe is a problem and react to it with policy in an attempt to solve it, while conservatives will look to create the conditions for growth. You can quibble with the contrast that Levin draws, but it resonates with me. In thinking about how to regulate technology, one thing I have always tried to keep in mind is the long term. If you ban acquisitions, what will that mean for exit by entrepreneurs and venture capitalists? And what will that mean for the investment and innovation that have driven the American economy and our soft power around the world? Before we get to trade-offs, though, let's examine how rein-in big tech fares on our regulatory flowchart. The frequency of the use of the phrase big tech seems inversely proportional to its utility. We hear it all the time, but it's just not a useful descriptor. Sometimes, as in proposed legislation to modify antitrust laws to bar Alphabet, Amazon, Apple, Meta, and Microsoft from engaging in conduct their competitors can, big tech is defined by the number of users and market capitalization that characterize a company. In substantial part, however, these are very different companies. That is, they do different things. So why we talk about them in the same breath and propose the same solutions to the problems they purportedly cause is far from clear. Microsoft's business is very different from Meta's, and Alphabet's from Amazon's. Some sell ads, some sell devices, some cloud services, some all of them. One often hears other companies described as big tech, for example, TikTok and Twitter. Those companies derive revenue from advertising, like Alphabet and Meta, and to a lesser extent, Amazon and Apple, although the FTC claims in court that these companies do not compete. But is Twitter really big tech? It's much smaller, for one thing, both by user number and by market capitalization. And the argument that it is a monopoly seems very difficult to make. I also sometimes hear words like gatekeeper and platform, as if those terms apply only to the largest tech companies. That is not true, not even close. Many businesses, online and off, are gatekeepers and platforms. More often than not, big tech just means apparently ubiquitous technology companies I don't like, with definitions like in the proposed bills looking more like gerrymanders to capture as many that you dislike without capturing too many that you like. The problem with it is that it addresses companies, not conduct. We know who, but not what, we would regulate. And that is not a recipe for sensible regulation. And rein in how? The antitrust bills certainly would have the effect of limiting the ability of the companies in question to compete on a level playing field with their peers. But when it comes to regulation, I tend to think less of entities and more of conduct or its effects. We want to reduce mercury emissions, and so we pass the Clean Air Act. It's not that we want to rein in Valero or Chevron. The question isn't whether to rein, although that's a question too, but how. Rather than being preoccupied with targeting a group of companies, policymakers should first identify what we perceive the problems to be. Is the problem restraints on competition? Or even efficiency that undermines an aesthetic preference for small businesses? I think there are problems with that argument, but it is an argument. Is the problem the collection and sharing of sensitive personal information? Is it content moderation policies that result in discrimination against unpopular viewpoints? These are different things, and different problems warrant different solutions. If we identify multiple problems, and that's okay, there is no reason to believe one solution will solve them all. To some extent, part of the definition problem is a grand rhetorical expansion of antitrust undertaken by those who see big corporations at the heart of nearly every problem. Big is not bad, but even when big gets bad, and it sometimes does, while antitrust is a powerful tool, the laws are not designed to address every problem we might associate with bigness. Even perfect competition cannot solve every problem. We've heard anti-monopoly warriors promise that antitrust can solve everything, from the political power of large corporations to privacy, to labor rights, to racial inequality. Does competition help address social problems? Without a doubt. When companies compete to lower prices, for example, people with fewer means have access to more products. That is good for distributional equity. But antitrust will not solve every problem, and it is not and should not be a regulatory catch-all. Let's go back to Levin's dichotomy between conservatives focused on long-term growth and progressives identifying problems and responding with solutions. When it comes to tech policy today, many would-be conservatives sound a great deal like progressives, identifying problems and responding with solutions. Fair enough, but let's marinate a bit on the problem identified most often. Conservatives are concerned that technology platforms are censoring them, specifically deplatforming, tagging, demonetizing, and otherwise quieting voices with which the companies or their employees disagree. I personally find it hard to explain some of the editorial choices I have seen, especially in light of some of the other speech not similar to the same treatment. I get the complaints. Above all, this cuts to the deeply problematic issue of how to moderate content at scale. More commonly on the political left, we hear moderation concerns, but in the opposite direction. These are calls not for more content, but for less. Concerns about the spread of hate or misinformation or the like. The complaints here, not enough content and too much content, are diametrically opposed. But we often hear agreement on the solution. How can that be? Whatever it is and however it works, no solution can solve both problems. Take repealing Section 230 of the Communications Decency Act, which the President of the United States recently endorsed. I'm no Section 230 scholar, and the FTC does not administer the provision. Courts do. But at core, it limits liability for hosting speech. Liability is a tax. When we increase liability, we get less of something. When we limit liability, we get more. That is how liability functions in our legal system. If you repeal Section 230 and increase liability, you will see less speech. So how does repeal result in less censorship? The argument makes little sense. That you might cudgel some companies that have made decisions you don't like seems on some level beside the point. How will the solution address the problem? And likewise, antitrust. It is not clear to me how breaking up big tech companies would result in the desired content moderation outcome when we have little social consensus and little market indication about what level of moderation is optimal. Why anyone assumes that a market functioning without whatever impediment they perceive would yield the moderation decisions that they want is not clear. How to moderate content at scale is a terrifically difficult problem. And many regulatory responses, or most, are fraught with First Amendment problems. But ultimately, is it a competition problem? People have a lot of issues with Twitter's moderation calls, but how exactly do they stem from monopoly power? And why does anyone think that were Facebook to sell Instagram and WhatsApp, conservatives would get more favorable treatment? And if competition is not the problem, antitrust is not the solution. The big tech conversation has also given us an odd variation on the old Washington joke that when you don't want to deal with an issue, you create a task force. Every few months, there's a proposal to create a new agency to regulate big tech. That may sound good to some, but it simply punts the critical set of questions we've been discussing. What problem would a new regulator solve? A new set of authorities might solve problems the law today cannot reach. That's fair. But a new entity in and of itself solves nothing. Another problem we hear about is privacy. And to be clear, I do see a problem. But one thing I hear a lot about that doesn't seem like a solution is, again, antitrust. I like competition and I like privacy. But the argument that antitrust will get us the privacy we want is, as I have said repeatedly, wrong for several reasons. Antitrust and privacy have different goals and are often at odds. Antitrust is focused on protecting competition, and privacy is about protecting information about people. Advancing privacy interests can decrease competition by limiting access to an asset from which value can be derived. When companies like Apple or Google restrict third parties access to data they have about customers, that might enhance consumer privacy, but it stops companies from being able to use that data to build applications and services that might benefit consumers. That likely decreases competition. I'm not saying that's bad, not at all. Sometimes we want to displace competition in favor of other values, but it is a choice between two mostly competing goals. Would greater competition yield better privacy? It might, if the competition is over privacy, but that ain't necessarily so. TikTok, the most downloaded app in the world, appears to offer less privacy than Meta or YouTube. It's competing along different lines. And if popularity is any indication, it's not clear that many consumers care as much about what TikTok does with their data as other features. Some do, to be sure. I think they should care more. And I certainly think the government should care. But privacy does not appear to be an offshoot of competition. Privacy concerns are a kind of externality, a byproduct of market forces. And to address them, what we need is privacy regulation. Congress is currently working on developing baseline consumer privacy legislation, most notably the negotiations concerning the American Data Privacy Protection Act, the ADPPA. There are a lot of thorny issues involved, and there are important trade-offs that must be made. Any legislation that restricts the collection, use, or sharing of data is necessarily going to have effects on competition by raising barriers to entry and increasing costs. And that is likely to entrench larger companies that can handle these additional costs and could result in fewer product offerings and innovation. And that is why any decisions this consequential properly belong to Congress. And I appreciate its continued work in this area. One thing the ADPPA reflects is the recognition that privacy concerns are not just about big tech. There are big technology companies that raise privacy concerns, but there are also small ones. And this is evident from even a quick perusal of the privacy docket at the FTC over my tenure. The big fish get in trouble, but that should not distract attention from the smaller ones, which can also cause some real privacy harms. The legislative discussion about privacy is about business practices, not individual companies. It takes a set of concerns, privacy, and fashion solutions calibrated to addressing them. There is debate about the particulars, but there should be no debate about whether the basic approach to policymaking is sound. I am less impressed with the Commission's legislative foray into privacy. Our August advance notice of proposed rulemaking on commercial surveillance and data security. I dissented for a variety of reasons, including legal and philosophical ones. But one big concern for me is that the ANPR reads as if there is such thing as a free lunch. There isn't, which is to say that regulation necessarily results in trade-offs, a fact the ANPR fails adequately to recognize. It paints common business practices in an entirely negative light and never recognizes any of their benefits or concedes that there might be costs to banning or limiting them. For example, the ANPR evidences a real hostility toward targeted advertising, but is essentially devoid of any acknowledgement of its potential benefits. Advertising is the engine of the internet economy. Instagram and Gmail are free because the companies that offer them sell ads. Some consumers probably like that they are free and want them to remain so. Consider also the businesses that buy the ads. Targeted ads are some of the most lucrative, and rules reducing or eliminating them will impose economic costs. In the wake of Apple's implementation of its app tracking technology, companies like Meta and Snap have reported substantial revenue losses. That means fewer businesses are investing in advertising, which they do in substantial part to reach customers and generate growth. The ANPR's failure seriously to grapple with these facts is a legal one. For the FTC to ban or limit the practice, it would have to prove that the targeted advertising causes substantial injury to consumers that is not reasonably avoidable and that is not outweighed by any countervailing benefits to consumers or competition. But it is also a failed approach to tech policymaking because it does not seriously recognize trade-offs. Our recent AI report to Congress was regrettably similar. Congress tasked us with conducting a study and reporting on whether and how artificial intelligence could be used to identify, remove, or take other appropriate action to address a variety of online harms. The report merely cataloged criticisms of AI and focused on its shortcomings. Consider the discussion of the use of AI to identify and remove fake reviews. The report notes that fake reviews are still on the internet and concludes that therefore AI technology is still not good enough. But compared to what? There is no analysis of how many fake reviews are found and taken down by human reviewers, and no attempt at balancing whether the costs of some fake reviews going undetected by AI is outweighed by the speed and cost saving over having humans do this work. It is folly to take such a one-sided view of practices and use that jaundiced view as a basis for sweeping regulation. Regulators should aim to avoid unintended consequences, and that's only possible if they have a complete picture of technology and practices, the good and the bad, before they embark on regulation. My friend and colleague, Commissioner Christine Wilson, reminds us of some of our nation's regulatory misadventures when we have tried to displace competition with other public interest values in the past. The railroad and airline regulations once administered by the Interstate Commerce Commission and the Civil Aeronautics Board, both now defunct agencies, are warning signs. Those regulations caused enormous consumer harm in the form of stifled innovation, decreased output, higher prices, lower quality, and decreased efficiency. The history of antitrust legislation includes many unintended consequences of short-term policy changes. The 1950 amendments to the Clayton Act, which are good and which we use today, were followed by a 2-decade merger wave. Their result was not the diminishment of powerful corporations, but rather the rise of gargantuan, unwieldy conglomerates. The Robinson-Patman Act sought to protect small retail businesses from larger, more efficient chain stores. And the unfortunate result was that American consumers paid more money for the groceries and household products they use every day. At a time when inflation is at a 40-year high, I'm especially wary of legislation or regulation or even enforcement that would take money out of the pockets of American consumers. Whether it's legislation or regulation, we need to take these costs into account. And the same holds true for difficult antitrust cases, a fact I have tried to make clear from day one. Take the thorny interplay between intellectual property protection, which supports innovation by displacing competition for a limited time. I issued my first dissenting statement at the FTC in the 1-800-CONTACTS case, just 6 months into my tenure. 1-800 sued rival contact lens sellers for trademark infringement when the other seller's online advertising appeared in response to consumers' internet searches for 1-800-CONTACTS. The resulting settlements required, among other things, that 1-800's competitors would not bid on the company's name as a keyword in online search advertising. The FTC sued 1-800-CONTACTS, challenging the trademark settlements. The administrative law judge ruled for the agency and the commission agreed, but I thought we had it wrong. I thought that settlements of trademark suits should be analyzed under the rule of reason framework, not the inherently suspect analysis the commission used. That presumptive liability standard applies only to behavior that judicial experience and current economic learning show warrants summary condemnation. But this was intellectual property, and I was concerned that condemning these settlements, these trademark settlements under the antitrust laws, would undermine the incentives to invest in costly innovation that intellectual property rights are designed to protect. And innovation is pro-competitive. The US Court of Appeals for the Second Circuit vindicated my position 2.5 years later. It held that a rule of reason analysis was necessary because this type of restraint, these trademark settlements, had not been widely condemned. And the protection of trademarks constitutes a valid pro-competitive justification. The inherently suspect framework is reserved for agreements well known to result in anti-competitive effects, and it is not and should not be a shortcut to liability for antitrust reformers. That said, neither should IP be a complete shield to liability. In the impacts case, I joined my fellow commissioners in condemning a reverse payment settlement under a full rule of reason analysis. In January 2017, the FTC charged that Impacts and branded drug manufacturer Endo Pharmaceuticals for illegally agreeing that Impacts would delay launching its generic version of Endo's branded extended-release opioid pain reliever, Opana ER. In exchange, Endo paid Impacts more than $112 million. Our unanimous commission applied the rule of reason analysis the Supreme Court articulated in the activist case. We found proof of a large unjustified payment made in exchange for deferring entry into the market or for abandoning a patent suit, taking into account all value that the branded manufacturer transferred to Impacts, the generic, through the settlement. Further, we found that Impacts failed to show that the settlement had a pro-competitive effect because the purported benefits of the settlement could have been achieved by settling without a reverse payment for delayed entry. Impacts appealed, but the US Court of Appeals for the Fifth Circuit affirmed our ruling. Antitrust and consumer protection unfairness law command us to recognize trade-offs. Prudence also dictates that we do. My firm belief is that when we do, we get the right result. My concern is that when we fail to do so, we get the wrong one. Technological development disrupts, improving lives, but also presenting challenges. That is generally true, and particularly notable with the development of communications media. Some of those challenges warrant regulation, but regulatory efforts must be thoughtful. Much of today's conversation around regulating big tech falls short. Sensible regulation is not a headline. It requires more than 280 characters. If we want to get it right, we need to consider clearly articulated problems, tailor solutions, and recognize trade-offs. Thank you again for inviting me, and I'm looking forward to our discussion.
Commissioner, that was an extraordinary talk, one of the most thoughtful talks I've heard in a very long time. And you've touched on a great many issues. And I'm going to try to keep my questions tailored to specific areas, or else I'd keep you here all day.
And my apologies, Harold, for going on so long.
Oh, no, it was wonderful. It was a wonderful talk. And I'm sure a lot of people are going to enjoy hearing it. I want to drill down. You've raised a very important set of principles: define a problem, define a solution, and look at trade-offs. I'm going to start with maybe the middle one, the solutions, and I just want to get your thoughts on whether the FTC is the right solution for a certain set of problems that the FTC seems to be addressing. And I'm going to start with a press release that the FTC issued just a couple of weeks ago about FTC to crack down on companies taking advantage of gig workers. This is not a parody. For those of us unfamiliar with the FTC, it almost reads like a parody. No matter how gig companies choose to classify them, gig workers are consumers entitled to protection under laws we enforce. Is the FTC a labor law enforcement agency?
No. The answer to that is no. Now, we have, for example, in a case I'll describe in a moment, where certain kinds of actors are not employees, we have used consumer protection law. So in a case from a few years ago involving Amazon Flex, these are independent contractors, people who sign up to offer their cars to Amazon to deliver packages, rather like Uber drivers give rides to riders. Amazon was lying pretty brazenly to the drivers about how much of their tips they could keep. And we sued them for it, and we settled with them, and we got the consumers their money back. But critically, these were not employees. And one of the problems that I have with the gig statement that we put out is, and the quote you read is right on point, it entirely ignores the distinction between employees and others, and in doing seeks to regulate, essentially, as consumer protection, all of labor relations. And first of all, that's not how American law works. The distinction between independent contractors and employees is like fundamental to how we structure labor regulation. But also, there are a number of agencies that address these issues, whether it's in the context of collective bargaining or workplace safety, you name it. Even in the federal government, agency after agency after agency, but also at the state level. And through the development of state statutes and common law, we have a reticulated system of protection for employees. The FTC is not part of that system. And I really, one of the things I did not like about that statement was the failure to recognize as much.
It seems like there was no limiting principle. One could have substituted shareholders of publicly traded companies or environmental situations, and at some point you tie it somehow into consumer law, and it just seemed like there's no limitation on the FTC's regulatory authority.
Yeah, it was a pretty big declaration. I think one question that I have, another criticism that I had with the statement, I felt like it was creating a lot of expectations for our legal capacity and also institutional capacity that are unlikely to be met. It's very easy to write words. It is quite a bit harder to sort of actually do what you're not designed to do. And I do think that's problematic.
Yeah. There was also an antitrust component that baffled me. I think other than possibly professional athletes, it's difficult to think of labor markets where there's a meaningful monopsony, the demand for their services.
But look, I will say something. I think that the work, it actually began in the Obama administration and continued in the Trump administration. The work of scrutinizing restraints of trade that apply to labor is a real and important line of work for the antitrust agencies. So you think about no poach agreements.
Yeah.
There is absolutely work to be done on the labor side, but that does not mean that all the work that anyone thinks ought to be done in terms of labor is work that the antitrust authorities are empowered or capable of doing. Again, we have a regulatory system. We have a legal system that speaks to these issues. And if we think it's not adequate, right, there are remedies to that. There's also a weird kind of anti-competitive nature to some of the statements. There's a line in the gig worker statement that says that when it's like worker cartels, we shouldn't do enforcing the antitrust law. And I've been on panels with people who think, where they're sympathetic and it's the little guys and the big corporation, we shouldn't waste our time with that. But the truth is, whatever you're advocating for at that point, if you're advocating for cartels, it's not competition. It's something else. Worker empowerment, call it what you want, but don't call it antitrust. Don't call it competition. If you're for cartels, there's some other value that you're seeking to enforce. I'm not sure if it's out yet, but there's a case we are announcing today, and folks who are interested in this particular issue should read the statement that Commissioner Wilson and I put out. And to be clear, in our view, the agency is doing the right thing on this count.
You mentioned several times privacy, and I take your point exactly. Why is privacy a big tech problem rather than just a general problem, and why this obsession with a handful of companies rather than anybody else? One of the lessons from GDPR in Europe is the paradox that some people have pointed out, that in fact the beneficiaries, if it's possible to think there are any beneficiaries to GDPR, and I'm not sure there are any, but if there were, it actually may be large companies that can afford to hire the lawyers and other experts to comply with the regulations, and that smaller companies are put at a competitive disadvantage by these onerous rules. And we're seeing California and other states adopt privacy laws. Is there a concern that if Congress doesn't step in, that however bad the situation is for privacy today, that it actually may only get worse if we adopt rules that tend to favor one set of companies over another?
Look, I think when you adopt a regulatory scheme, especially a complex one, there is a natural tendency for it to favor the larger firms. They're bigger, and so compliance costs, which are subject to the same economies of scale of other things, can be spread out more widely. They already have the lawyers, and so they don't spend as much relatively, whereas smaller firms will have to allocate resources that would otherwise go to coders and engineers. So I think that's a real thing. Let me say the following. In America right now, we have a proliferation of state laws addressing privacy. So the compliance costs are here. And I do think that's one reason. Addressing some real privacy concerns is another, why we appropriately are at the point of considering national legislation. Now, I think we should learn from GDPR. I think we should look at what works and what doesn't, what we really care about, what we don't. What are the problems that we're trying to solve beyond a sort of vague notion of creepiness, or commercial surveillance is the phrase that we use in our ANPR. So I think it's time that we do it, but I think we need to be clear-eyed, right, about being careful. What are the problems that we're solving? And what are the trade-offs? Because if you think that you're going to pass a massive regulatory rule and rein in big tech, you will stop them from doing certain things. You will also stop others. And that may be worth it, but don't think that's going to make them smaller. It's just not the law ought to be justified on its own terms, right? Which is, we want, these privacy goodies, and we're willing to pay these economic costs.
In discussions about that, I'm sure you have with various people about potential legislation of quote unquote big tech. Big tech seems, you're right, it's meaningless. There's no commonality among these companies other than, as you point out, size. There's another commonality. These are all American companies. And in a global market such as the internet, uh, is is there some advantage to the United States that these companies, the largest corporations in the world, whatever it is they do, are based in the United States and not elsewhere? And if we make life too uncomfortable for them, why they wouldn't just migrate offshore to Bermuda or someplace else that isn't going to harass them?
Look, I tend to think in general the answer is yes. Yes. Now, look, the last time you and I spoke, which is in this context, it was almost 2 years ago. And I said then, I'm not a fan of national champions. I don't think we should give our companies a pass on legal compliance. But I do think the fact that the companies in question are American makes doing whatever to them a lot easier in Europe, right? It's a lot easier to say, we'll do it to your guys and not to ours. But TikTok is a great example, I think, of what you're talking about. There is a level of concern about privacy that TikTok presents that I don't think the American firms present in the same regard. And that is this. Some people have big concerns about what the national security authorities do and law enforcement does, but we have a legal system here in this country. And you can get access to information about people based on statutory and constitutional rules that have been developed over time with a great deal of thought, including with privacy in mind, right? Both under the Constitution and under statutes, like ECPA, Stored Communications Act, and so forth. That's not necessarily true in China. And so whatever access you like or dislike the government having for data about people, TikTok is going to present a kind of issue that American firms dealing with data about Americans just aren't going to present. And so I think, yes, fundamentally, right, if you were going to have big companies, we'd rather have them here, right? And I think that helps in general. Just to be clear, I'm not arguing for a minute that American companies should be exempt from enforcement, that the companies don't present various issues. But I do think that, when we think globally about where the US is, we should recognize that the efforts of others to weaken American companies may have considerations behind them that really aren't considerations that should resonate with us.
Exactly. Yeah, the Europeans and GDPR have one set of policy objectives that may be a little different from ours, to be sure. You mentioned, and I was chuckling when you did, these efforts to put AI, that somehow AI is going to solve privacy problems or content moderation problems. It's so you just label something a black box, call it AI, and somehow that's going to solve problems. People take this seriously? Is this really real?
Well, so the congressional report that we were asked to prepare was an evaluation of how useful AI was to solving a set of problems. And let me say the following. I think AI has a lot of potential. It's obviously not great at doing a lot of things, and there's some things it's never going to be able to do. I feel like we should all just stipulate to that. My issue with the report we did wasn't that it was Pollyannish about the potential of AI, but rather that it ignored the question of, like, how useful is this tool for addressing these issues? That was the congressional question. And rather it was just like, AI is all bad. And I don't agree with that either. To me, it's a tool. And they're like other tools, right? It will have impact. It's certainly not perfectly efficacious. I gave the example of fake reviews, removing fake reviews. It's perfectly reasonable, as the report does, to say AI doesn't rid us of the problem. But I do feel like part of the discussion, especially when the question is AI good at doing this, we have to view it in light of, well, what are the other tools that we would use? And how would we address that? Because the fake reviews were there before, the AI tool. I'm not Pollyannish about AI's potential, but I'm not a Cassandra either.
I think that's fair. I think that's fair. I see it in other contexts, and it just seems to be if you have a problem, AI can solve it, and I just think that's a little naive.
I'll say the following, and AI is hardly the only context, right? We see this now with blockchain. There is a sense in which there's a kind of messianism that comes with big technological developments. The internet. The internet has brought us a lot of good, but as I was saying before, it also presents challenges.
On the question of kind of state level laws and regulations, we're seeing a lot of states look at content moderation, passing laws that have been challenged in courts with different results in federal courts. 11th Circuit going one way, 5th Circuit going another. Do you have any thoughts about, first of all, just state level laws on content moderation and relatedly how all this plays out in the federal courts?
Look, I'm going to leave it to the courts to answer those questions. I did mention in my speech that the First Amendment issues of how you address content moderation problems seem obvious to me. We now have two very smart judges on two different federal courts, Kevin Newsom and Andy Oldham, going in somewhat different directions. And I feel like we're going to get greater clarity on that as time goes on. So I'll kind of leave the law there. My sense is that how you moderate content is a speech question. And I do think, again, I understand the impetus, I understand the impulse. I do think we need to be careful when we talk about speech regulation, because that's a context where the baby really can get thrown out with the bathwater. I continue to believe this is probably the trickiest tech problem, or one of the trickiest tech problems of our age, because it's not without cost when you give everyone in the world a microphone and a mechanism to meet one another. People have some bad things to say. And, if you look at like Neil Ferguson's history of what happened when the printing press came out in Europe, and you look at more recent history of the development of radio or television, there is nary a communications medium that the development of which hasn't brought with it terrific instability. And I think social media is part of that. Very much so. It is deeply unsettling. How we grapple with this issue, who should have which responsibilities. I think, again, I wish I had an easy answer. If I did, I would be out there with a megaphone shouting it to the hills. But it is it's legally difficult, but I think it's also difficult as a policy matter.
What about the issue of whether these are issues, social media platforms or privacy, for that matter, are these state issues or are they inherently federal issues?
I'm struggling to think for a minute. They're clearly not inherently federal issues, right? Unless the federal government specifically kicks them to itself. I do think, and I'll use privacy as an example, we need to think in part about the policy consequences of having a lot of different rules, because whether it's social media or other kinds of technologies that implicate either content moderation, but especially privacy, you have all sorts of firms all across the country, and the data moves across state lines very easily. And I think there is both a business, but also a consumer reason to want to have a coherent set of rules. So the business reason is because it's more efficient. And whatever level of competition you might displace with one set of rules, having 50 sets of rules, or even just 7 or whatever, is going to make those compliance costs much greater. And that's sort of generally a negative. From the consumer side, though, I think there's also an important thing here, which is one of the things, especially with privacy, that people talk about is they don't know what's going on. right? It's confusing. What's allowed, what isn't, is part of that confusion. To the extent we have a variety of different rules, you're going to magnify that confusion. And so I think for businesses who want to be on the right side of the law and want a simple set of rules, it's good to have one law. But also for consumers, right? We're going to teach people this is how this works. When you click OK, this is what they can do or what they can't. Right? We're adding consumer understanding. People talk about, I don't know what's going on. If consumer understanding is part of the goal, and it should be, or at least greater consumer understanding is part of the goal, and again, it should be, I think having one set of rules makes a lot of sense there too. So both on the business and the consumer side, while states are free to do it, and I don't think it's an exclusively federal interest, I do think as a matter of public policy, preempting the state law and having one federal law makes a whole heck of a lot of sense.
Do we see, though, the possibility of websites and services migrating in response to different state laws or different national laws? Right now, we have a world in which there are a variety of different privacy laws, although it seems like a lot of websites simply have adopted GDPR as kind of a default set of privacy rules. Is there concern about sort of a balkanization of the internet into a lot of different legal fiefdoms?
So I think the short answer is yes, right? The legal barriers that you'll see from time to time, especially from the courts in Europe, to data flows that are international, will have a disruptive effect. And I think one thing that you hear a lot of chatter about, and some laws internationally passed regarding, is like data localization, right? We're going to make sure you're following our rules because the data isn't leaving our jurisdiction. Now, I tend to think there ought to be some balkanization along the lines of fundamental values. So to me, I would allow more data flows between us and Europe and Latin America, places, where we have similar systems of government and democratic values, whereas a Russia or a China, you might want to have a great firewall for our purposes too. That's not good for their people, but those lines make a little more sense to me. Are we seeing migration like within US states of companies? I haven't heard that yet. It's plausible. But definitely, I think the trend, even among liberal democracies, is toward a little bit of localization and balkanization. And in a sense, I think that's bad.
In your comments, you mentioned the really nightmare scenario where the FTC might try to ban ads on certain types of platforms, harming obviously not only businesses but consumers as well. Does the FTC have the authority to ban ads on various platforms? Does that authority exist?
So fundamentally, I don't think the answer is yes. Our advance notice of proposed rulemaking suggests we do. What we have authority under the law to regulate or ban is unfair and deceptive acts and practices. Now, an ad, unless it's a deceptive ad, isn't deceptive. So then we're down to unfairness, and there's a test for that legally. And it's very hard for me to think about how you would fit more targeted advertising into the bucket of unfairness. Now, the agency did a little bit of this with kids in the 1970s, and the result was that the agency was shut down and we had to issue an unfairness statement, which Congress later codified in the 90s to prevent us from doing that in a context which is at least more suggestive of a problem than what we're talking about here. And so how you read our statute to enable us to do that is very difficult to me, but there are a lot of intimations that others disagree with me on that. One of the really interesting things in the development of the economics of consumer protection law over the last 4 decades is that we went from a place where a lot of people really thought about advertising writ large as kind of predatory, that it would encourage people to do things and buy stuff that, do things that weren't good for them, to buy stuff they didn't need. And a lot of economists looked at this question. They sort of studied the effects of advertising. What they learned is it's not just good for businesses, it's also good for consumers. It supplies us with information that allows us to do better at shopping, right? And it allows the market, thusly, to work better, right? The signals that are the market are working more efficiently when you have advertising. And I do think a lot of the rhetoric in the context of the internet these days, especially in the last few years, has really returned to this antiquated notion of advertising as kind of fundamentally predatory. And I just don't think that's right. Like, I think it's good for businesses, but it's also good for consumers.
You've spent some time on Capitol Hill, and you've obviously served well as an FTC commissioner. And you made some comments about unintended consequences of antitrust legislation. Any guidance to Congress about whether and how it should craft new legislation, whether it's on antitrust or consumer protection, to avoid unintended consequences?
I mean, I think the first thing that I would say, especially with respect to some of the antitrust proposals that really do answer the rein in big tech call, that is, they try to specifically inhibit certain companies from doing things other companies cannot, without a good sense of how that solves, other than weakening those companies, the problems. I think it's what I said, sort of part two, which is you got to identify the problem. If you've got a business practice and you're not persuaded it's something in which companies should not engage, why bar it? Or if you have a business practice that you're persuaded is bad, why allow most people to continue to do it? It doesn't make a lot of sense. And I think focusing on what is the problem that we're trying to solve and how does this solve the problem, to me, is the most important message.
Yeah, sadly, I think you're exactly right, though. It seems to be they've picked the scapegoat, and they're legislating at times, it seems, to on scapegoat, as nebulous as the scapegoat is, and that's very problematic. And the scapegoat being big tech, whatever that is. Commissioner, you have been a voice of reason at the FTC for several years now, and that voice of reason is going to be very much missed. We wish you well in the next chapter of your illustrious career, but we very much will miss having you at the FTC. And we look forward to welcoming you back at Hudson in your new role, whatever that might be.
Harold, thank you so much, and I look forward to it.
Thank you.